In the studio with me is the General Counsel and Director for the Free Enterprise Project over at the National Center for Public Policy Research, a conservative think tank. Nationalcenter.org is the website. Justin Danhoff is his name. Hey, Justin, welcome to the program.
It's good to talk with you, Tom. Thanks for having me on.
Thanks for joining us. Did I accurately characterize National Center?
That's right. We're a conservative think tank, been around since 1982.
Okay, so you have some thoughts about free speech and hostile work environments. In fact, did you write this? Or?
Yes.
Yeah, okay. Government may soon direct what private sector employees may say in the workplace. Doesn't the government already direct that? I mean, if I walk up to one of my employees and start calling them obscene and offensive names, they have the basis at law for arguing that I've created a hostile workplace and I'm an abusive boss and, for having some sort of an action against me, whether it's monetary damages or whatever. I mean, what's wrong with that?
Oh, I would help your employee in that situation, Tom. And what we're talking about is provocative speech that's not obscene, that doesn't cross the line into epithets, name-calling, things of the like. We're talking about in this day and age, after the Trayvon Martin, George Zimmerman incident, after Michael Brown's shooting in Ferguson, Missouri, we have political pundits, we have politicians calling for frank discussions about race. And what we have highlighted is a North Carolina case that shows having a frank discussion about race is wrought with peril for the American worker because of hostile work environment laws that are very vague in breadth. So the arbiter, whether that be a judge, a jury, an administrative law judge, has wide latitude in deciding those types of cases.
You would want them to, wouldn't you?
Yes. Well,
I mean, what's reasonable? And what's reasonable is going to vary from circumstance to circumstance and person to person. But the case you have right here is where a supervisor, presumably a white supervisor, was reading a Facebook post, and it was basically the Drudge Report take on the killing of Trayvon Martin, which was, why isn't anybody talking about this white child who was shot by a black man? And, I mean, there are so many layers of BS in that. The fact of the matter is that we have systematic, across the United States, it was institutionalized at law for over 400 years in the United States and pre-United States, and now is, if not de jure, certainly de facto, the criminalization of blackness in this country. And this supervisor's reading this Facebook page saying, in the voice of the 13-month-old kid or whatever, saying, why isn't anybody protesting about me? Why are they all protesting about that black guy getting killed? If I'm African-American and my boss is talking like that, I mean, this is a cue that either A, this guy is totally clueless or ignorant, or B, a racist. I would feel intimidated.
Well,
how can you defend that?
I don't think you can say that there's racial animus in just reading a post that's factual, right? There was no racial epithet.
It was not factual.
What wasn't factual in the post?
The post asserted to know the mind of a 13-month-old white kid.
It was from a perspective. There was no one in the room who thought the 13-year-old wrote this Facebook post. 13-month-old, I'm sorry, yeah. White baby wrote this Facebook post. It was obviously from an imagined perspective.
But it wasn't factual.
But what wasn't factual about the fact that there was 24/7 coverage of Trayvon Martin's death, and until you read that North Carolina case, had you ever heard of that 13-month-old baby being shot at point-blank range?
No, I hadn't, and I shouldn't. We don't have a systematic crisis in the United States of black people killing white babies. We do have a systematic crisis in the United States of white people killing black people, particularly white people in authority figures or wannabe authority figures like George Zimmerman or Officer Wilson in Missouri. These are real, serious, not just public health issues, but criminal justice issues.
Okay, so what I'm trying to get at here is that talking, whether it's about race, whether it's about sex, whether it's about national origin, whether it's about sexual identification, all of these issues are wrought with peril if you talk about it at the water cooler. That's the larger point I want to make.
Exactly right.
If two black employees were talking about the pathetic athleticism of a white employee, that white employee may have a claim now. But let me give you another example.
How is that bad?
I'm saying it comes from all sides. So let me give you an example. Say two white middle-aged men are talking about their sons applying to college. Say that they do not like affirmative action because they think it disadvantages their son. And a black employee walks by and hears them say, well, black and Hispanics who are undeserving may get the seat that should go to my son.
Well, it's not a statement of fact. They would be deserving by definition. If they got the seat, they were deserving.
Through affirmative
law.
action. Is it okay to disagree in the public workplace about affirmative action?
I think your individual example is a straw man argument. Hey, let's find this the most innocuous or close to innocuous example that we can and put that forward. The law is not there to deal with the reason why judges have wide latitude is when you get into these gray areas.
Well, I think what the problem is it's viewpoint discrimination, right? That's what we're talking about here. So it's from my viewpoint.
No, it's not viewpoint discrimination.
Yes, it is.
It's discrimination against...
It's content and viewpoint both.
Against the words that you're missing here are against protected classes of people who are essentially minorities, or people who have been disempowered, like women who are not a minority, but have those same functional protections because men have been so successful at oppressing them all these years. I mean, look at the percentage of women who are running major corporations in America, the number of women who are serving in our legislature.
Right, and President Obama's White House won't pay him an equal pay either.
Go after him. Go after him. You have my blessing. Those are legitimate things. I mean, what's your remedy? What's your proposed remedy to this?
Get the government out, right?
In other words, just let people trash their employees.
No.
Let people intimidate their employees.
Absolutely not.
Then you want the government in.
Where there is real harassment, there needs to be remedies. Where there is just frank discussion about honest situations and the government wants to come in, let's talk about college speech codes. This is the area where I'm going to offer some advice out there. Those who have faced these lawsuits in the college speech code arena have fought back on First Amendment grounds and been able to kick a lot of these to the curb. Most times when employers are involved in these hostile work environment lawsuits, they just settle. They don't want the publicity. So the legal cases, the EEOC, since Eric Holder has taken over the Justice Department, since we have President Obama, we have a race-centric way of justice in this country.
Is this a conservative argument for, oh my God, we got a black guy in the White House?
I spent the entire morning, Tom, going through the EEOC case log. There is not one instance since 2008, since President Obama came over, where a white employee was successful in a hostile work environment suit against superiors who were minorities. Before that, we had lawsuits coming from every angle, from Asians, from Hispanics, from blacks. But now we don't have anything like that anymore. I think that those who are looking through a racial spectrum are doing so with a reason, and I think that's very unfortunate.
Well, assuming that what you're saying is true, and I have no knowledge of this, so I can't back up that assertion, does that not mean that the George W. Bush administration and all the previous white presidents before were largely ignoring issues that this president and this attorney general have decided to address? And
no,
again, what's your
there
problem?
Was plenty of lawsuits of blacks being oppressed in the workplace before. It wasn't.
So if your solution,
it was now it's solely that.
Is your solution a solution at law?
It's policy and law.
So,
right.
So basically, you're telling. I'm sorry, Justin.
I want all races of folks. I want all genders to be able to have frank discussions at the workplace that involve honesty. I don't want one class to be separated because they happen to be white.
And in a management position with somebody who's not white, there's a power imbalance to begin with. A, management position, and B, in our society, just white privilege. I mean,
I dismiss that out of hand. When you're talking,
you don't think white privilege exists?
I dismiss that out of hand.
That's incredible.
When we have our
what country do you live in?
We have more women going to law school than men, don't we?
What does that have to do with white privilege?
We're talking about gender disparity, race disparity. We have black and Hispanic students entering colleges that are way beyond the spectrum of their ability because they were given so many extra points
through
affirmative
Thom
action.
Hartmann Program.
Okay. Justin Danhoff, General Counsel and Director of the Free Enterprise Project, the National Center for Public Policy Research, nationalcenter.org. Thank you, Justin.
Thank you so much, Tom.
We'll be back.